this, but I do think it's important not to hold them as a group. I think it merits, in order to assure a fair trial, that it's free from any taint, interference, suggestion, even to the extent of driving by the state capitol this week. You're likely to have seen a poster. And I don't want jurors to think that they're getting themselves in trouble if they have seen something that may have caused them to think in an inappropriate way. But I do ask, Your Honor, with all respect for the time and the economy of time, but I think it is that important. Thank you.
State position.
Your Honor, I don't think we need to bring any additional to the time zones. I mean, colors brought out. I appreciate the fact that he brought it to our attention, but we can't control what the outside world does. And I mean, posts by people who are not involved in this case, that we had admonitions that were given, and to our knowledge, and what we know is the families done everything they're supposed to do. They've not posted, they've not engaged, they've not done any of the things that the court has asked them not to do. What the rest of the world does outside of this courtroom is what the rest of the world does. What the rest of the world calls us, calls prosecutors, I really don't care. You know, we're here to do justice, and that's why we're here now. To ask the jury to do something additional now, Judge, if they've got a question, they have the ability to write it down. They got the ability to say, hey, Judge, this did or didn't occur or whatever. And to my knowledge, that's not taking place. So in order to pull them out and start kind of poking and asking, you know, specific questions of them, I just don't think it's proper at this point. We've had other high-profile cases. We've not done it. We didn't do it in the Uber case here. We didn't do it. I mean, it's not been done that I can recollect. I'm not almost 30 years of practice law. I've not had a case where that's happened, and I don't think that we need to start doing it now. If the jury has a question, they understand your admonitions. These are grown folks who went through the process. They've adhered to everything that you've asked them to do at this point, and there's no need to start pulling them out and searching for something when they're not telling you that anything is going on. I don't think it's proper.
John, I would simply say that, as I mentioned, we sequestered juries for many decades. And we did so at a time when the only access that jurors could have to taint themselves were much less than today. There were 3 TV stations. There was no internet. There was no social media. There were neighbors. And those opportunities were the only opportunities to be tainted by public opinion. And yet, for 3 decades or 4, our courts sequestered juries. To the best of my knowledge, we stopped doing that because of the expense. Okay, I get it. But today, 1,000 television channels, social media platforms that allow the worst and most scurrilous, degrading, disgusting conversations, even to the point of threats of violence, threats of destruction. That is so ubiquitous, Sean. And I think, I don't know that I recall making a motion like this, but having gone through the crucible of the Murdoch case, I recognize a couple of things. The frailty of a jury's willingness to come forward. And that's a human nature. It's not a dishonesty on the part of the jury. It's just a belief that it doesn't need to be recorded. So I would ask again, Your Honor, while it may be novel, but I think it is necessary. And the mere fact that it hasn't been asked before of you or another judge, whether in this courtroom or another, I don't hesitate to have any embarrassment about asking you to do it now to ensure against the possibility that any juror has been contacted or otherwise stumbled in to the receipt of information. Thank you.
All right. Well, I don't know your position on that, Mr. Chow. I don't think there's any real procedure for doing that. I see it as fraud on a number of levels. If I were to go back there and examine each juror individually myself, again, based on what we learned from the court's ruling in Murdoch, I'm hesitant to have any sort of conversation off the record outside the presence of all the lawyers with any juror. So I will deny your motion in that regard. What I am going to say, though, too, is the stuff here that you provided is troubling, although there's been a lot of troubling things all weekend. lawyers, and I guess I'm more talking to the public here. We just all need to turn the temperature down, much like I talked to the lawyers Wednesday, to turn the temperature down. The public does too. This matter is actually only a matter of life or death for the Carmack-Belton family and the Chow family. The rest of the folks don't need to be sending messages like this to lawyers. I actually got emails myself over the weekend, which reminds me I need to send a sled. Please, folks, just turn the temperature down. There will be a verdict maybe here today, and we're all going to be respectful of one another. And I want to commend everybody who's been in this courtroom for the week, or all last week. Everyone here has been respectful to one another. There have been no issues, there have been no outbursts, and I commend you all on that for being respectful of your neighbors. But we're going to continue to do that, and that's how today's going to play out. So, with that being said, what else? Jury charges.
Yes, Your Honor. I think we just have two quick issues to bring up with regard to what the defense's position is with final charges. We did send an email to the court yesterday afternoon with the one edit and the one addition. First of those would be to add within the element about bringing on the difficulty. Our position is that the language and the court's draft, the cleanest way to make this edit would be at the bottom of 16 going into 17, that if the conduct of the person defended or the defendant was unlawful and of the type which was reasonably calculated to and did provoke a deadly assault, and continuing from there. In support of that language, we're relying on State versus Bryant, 336 South Carolina 340. That's from 1999, and that exact language was reiterated in Slater, and that's 373 South Carolina 66. And the direct quote from those cases is that any act of the accused in violation of law and reasonably calculated to produce the occasion amounts to bringing on the difficulty, and would bar his right to assert self-defense if those conjunctive conditions are met. So that would be the first request that we have. And we also do believe that the evidence adduced over the course of this trial does squarely put the issue of withdrawal in front of the jury, and that is a question that they must decide whether. I don't think it's going to be any surprise that the state will argue that Andy Chow and or Rick Chow were at fault in bringing on this difficulty. With respect to the testimony that we have received over the course of last week, Andy's conduct, his act, the jury could find that act amounts to a withdrawal from any potential difficulty the jury may have found he had brought on. And if that withdrawal was effective, then his right to self-defense, and by extension, Mr. Chow's right to defend him would be restored. And in support of that withdrawal charge, the language of which is one's right to self-defense is restored after a withdrawal from the initial difficulty with the victim, if that withdrawal is communicated to the victim by word or act. And that or act portion was emphasized, I believe, in State versus McCarty. That's 437 South Carolina 355. And that is also quoting the Bryant case at 336 South Carolina 340. We do believe that the withdrawal law does need to be charged to this jury in light of what's been adduced over the course of last week.
Continue, State.
I just don't recall any testimony regarding any withdrawal. This was one continuous act, John. I don't remember any testimony whatsoever of withdrawal. It was a chase that went 130 yards, and there was some backing up that was testified to, but it was right at that moment. This was a bam bam kind of situation the way it was described.
Okay. here's what I'm gonna do, and I did look at all this. As far as the violation of the law language, I'm not gonna charge on that. I think the implication of that charge would mean that it would have to be a violation of the law for someone to be not without fault. So I'm not gonna put that in there. I am gonna add the language of withdrawal. It is in the final charge. It would be on page 18 at the bottom. And here's the exact language. And it went a little further than what you asked for, Mr. Copeland, because I think you sort of cut it all short. Here's the exact language. One right to self-defense or defense of others is restored after withdrawal from the initial difficulty with the victim, if that withdrawal is communicated to the victim by word or act. Withdrawal from a conflict must be effectively communicated to the victim by word or act to restore the right to use self-defense or defense of others. An accused who provokes or initiates an assault cannot claim self-defense or defense of others unless the person intended both withdraws from the conflict and communicates his withdrawal by word or act to his adversary. So if we go a little further, then just, I guess you pretty much had the first sentence, but model charge that we have added, that basically has to be unequivocal, that the person defendant is withdrawing. So that's how I'm gonna do it. Y'all have been emailed a copy of the final charge as well. Anything else?
Are you intending on, or have you thought about, we're gonna send the instructions back to them initially, or just play it by
I
ear?
typically do not, and I will let them know that if they have a question about the law, the procedure for that would be to send me a note, and then I can recharge them on the law. I just get concerned that folks, this is intended to be interpreted as a whole, and I get concerned that folks, one person relies solely on page 17 and nothing else as a whole. I don't know whether I'm right or wrong. I know some of my colleagues send the charge back. That's the way I am. All right, you ready for closing?
Yeah, a little PowerPoint here, that's just gonna have some, so has the thing ready whenever. I know it takes a little time to fire up. We have it. Will it just be turned right on whenever we're ready for the first one?
It has moved to like extra.
Okay.
And you can tell the document you gave me, you did one to the court reporter.
I did not, Your Honor. I just passed it up to you, but I'll be happy to come up and hand it.
We make this a course next month.
Yes, sir.
I'm ready to hear it, please, sir. Yes, sir.